The honourable member for Toronto-Danforth.
Thank you, Mr. Speaker. I'm honoured to be rising to speak on C-46, an act to amend the National Energy Board. We know that this bill is dealing with the whole question of liability for pipeline spills. In my riding, Toronto-Danforth, is a very strong environmental riding. The environmental consciousness of the average citizen is exceptional. They're very concerned about the serious environmental risk associated with pipeline projects in Canada, including oil spills. And it's also important to say they also understand that pipelines are directly tied to the facilitation and the accelerated oil extraction and oil export. That is at cross purposes to the urgent need to fight climate change, the single most important challenge the world faces, and indeed the single most important challenge that we've been facing for decades without acting properly on it. And many realize also the particular risks of localized pollution of diluted bitumen once it spills in any form, whether from a tanker or from a pipeline, as the member from Saanich Gulf Island has been emphasizing in today's debate. My constituents have very little faith that this government is taking steps in general to ensure that these kinds of environmental concerns are thoroughly addressed. My constituents need to know that the environment is being protected and that necessary preventative and response measures are going to be put in place. Now, of course, I take these concerns seriously. When it comes to major resource projects like pipelines, the NDP believes that proper community consultation, respect for the rights and title of Aboriginal peoples, and rigorous environmental assessments are the bedrock of any kind of viable sustainable development approach. Right. Now, this has not been the approach taken by this government by and large. In the review, for example, Northern Gateway and Kinder Morgan and Keystone XL, and the same flawed process that was applied to Line 9 and now is being applied to Energy East. Now, the legislation we are debating today is, however, a step forward. Bill C-46 seeks, amongst other things, to ensure that some polluters will be absolutely liable for harm caused by a pipeline spill, including environmental damage, what is termed in the bill non-use harm. The bill includes absolute liability for all National Energy Board regulated pipelines, and that means companies would be liable for costs and damages irrespective of fault, up to $1 billion for major oil pipelines. That is, pipelines that ship or transport more than 250 barrels of oil a day. Where there is fault, including negligence, there is no cap, and that's a good feature of this bill. For those under 250,000 barrels a day, it's left to regulation. So there's a bit of a lack of clarity there as to what the liability cap will be for smaller operations. It's a good start, as I've said, and that's why, of course, I will be supporting it at second reading, and I think from what I've heard, most of my colleagues, if not all of them, also will be. We need to send it to committee for further study and amendments, and this is exactly the kind of bill when there will be real expertise brought to bear from across the spectrum. And I honestly hope that this is a committee that has enough hearings to go into the fine details of the bill to get it right. There seems to be a cross-party consensus that it needs to be gotten right by and large, and it's not the kind of bill that should be overly politicized. Now, we in the NDP have long been consistent in our position that companies, corporations, and not taxpayers, not citizens who are calling the public treasury for other government programs, should cover the cost of pollution. So the bill is long overdue as a first step towards a polluter pays regime for pipelines in Canada. And there's some other specific provisions I should briefly point out by way of being somewhat laudatory of what the government's put forward. In Bill C-46. One is that Aboriginal governments, termed any Aboriginal governing body, are treated similarly to other governments, municipal, provincial, and federal, in terms of the role they play in cleanup and being compensated for any kind of cleanup that they have to do. Their other powers and rights are given to them as well, and that's something. The fact that in the sections there are additional remedies as part of the judgment that a court can give under offence provisions of the National Energy Board Act include such creative possibilities as ordering creation of scholarship funds for environmental studies. This is written into the bill. Interim compensation is possible as one of the orders from the new Pipeline Claims Tribunal that can be called into being in cases of so-called designated companies. And the system that's set up by the bill has the ability to access as much of pooled liability reserve funds as the National Energy Board deems needed in case of designated companies, so that when a company is sharing a pooled fund to make sure it has enough money, it's not just its share of the pooled fund that can be accessed, but the entire fund, at least on my reading. And also, in terms of the kinds of fines that come with the offense provisions that already exist in the National Energy Board Act, there's a number of new headings on what aggravation of damages could be sparked by, what kind of extra factors would mean higher fines. And one of them is if evidence shows that the corporation allowed the spill to happen, essentially, as part of an economic calculus in order to save costs or in order to make more money. And so all of these things, I think, are to be commended in the bill. Now, there are, however, more than a few problems. And the first one has been mentioned a few times, so I'll be very quick about it. Setting the limit on liability in cases of a non-fault, so-called non-fault, at $1 billion may not be sufficient. The member for Sandwich Gulf Islands has already indicated clearly that although we know that it's already cost more than $1 billion for the cleanup in the Kalamazoo River area, we also know that the cleanup hasn't actually worked, and to some extent the attempt goes on, whether or not it's ever going to be possible given the nature of diluted bitumen. Secondly, under much of this bill is heavily laden with regulatory and discretionary provisions. An awful lot of powers given to the Cabinet and the National Energy Board to set out detailed regulations. And this includes, for example, that this new Pipeline Claims Tribunal it exists in the Act in a very, very general way. The Governor and Council, however, is given the power to make regulations on virtually everything to do with this tribunal, including, quote, prescribing the terms and conditions of appointment of its members, end of quotation. That's section 48.47. There's nothing in the Act. We have nothing to look at to know what kind of tribunal is this going to be. Where are these members going to come from? How are they going to be appointed? How do we know that this tribunal will be a fair and adequate replacement for the courts, for example, in the case of the stream of cases that might go to them? There's actually lots of room for manipulation of that Pipeline Claims Tribunal by virtue of so much being left out of the Act itself. Other problems are more in terms of how things are left to regulation, but the Act is taking care to make sure some things cannot be regulated. For example, it appears from my reading anyway that the Governor and Council cannot prescribe higher amounts than the $1 billion on a company-by-company basis. They're allowed to say, yes, for this kind of pipeline that's much more than 250,000 barrels per day, the liability limit should be more than $1 billion. But they can't do that on a company-by-company basis, although they're specifically allowed to do it on a company-by-company basis for pipelines involving under 250,000. Therefore, if you have a company that is notorious for having problems, notorious for non-compliance, notorious for being a greater risk, and yet still is in the game, so to speak, there seems to be a prohibition on treating that company differently. There's kind of a formal equality idea here. That's a problem, I think. In terms of the amount of cash on hand a company has to keep to cover liability, the National Energy Board is not required to make sure that the money on hand includes enough money for any potential loss of non-use value, which is code in the bill, for environmental damage relating to a public resource. And this is part and parcel of a couple features. We discussed it earlier in Q&A and from an earlier speech. A couple of areas in which, although the Act starts out by saying so-called non-use value, environmental damage, is covered as one of the three major heads of damage that this bill's liability provisions are meant to go to, there are other provisions in the Act that seem to claw that back. Really? So what I'd like to say in conclusion, Mr. Speaker, is that This is a good start, for sure. At the same time, it is a bill that needs close scrutiny in committee, and I think it's the kind of scrutiny that will be very easy to understand in terms of what is necessary to improve the bill, and I hope all parties will gather together to do that.
Good analysis here.